Good morning. Good morning, everybody. Attendees are rolling in. Welcome, Chesapeake Region Safety Council and our partners at MTBMA. Welcome you to today's webinar, 2024 Cannabis Update, Safety and Legal Considerations, presented by Adele Abrams. Good morning, Adele. This webinar is being recorded. The video and presentation will be available later on our website as a YouTube video under our resources tab, safety webinars. So when you check out that video later, be sure to follow us on YouTube while you're in there. There's a Q&A feature and a chat here on this webinar. Please use it. Put some questions in during the webinar. If you have questions that don't get answered at the end, we'll be sure to reach back out to you, either the council will or Adele. And if I could ask that you all stick around during the Q&A, I think that leads to some new opportunities, and we've got some new certificate programs that we'd like to share with you. If you have questions anytime after this webinar, go ahead and get your phone out. It's fine. Nobody can see you. Get your phone out, take a picture of this slide so you don't forget our email address and phone number should you have any questions for us down the line. I'm Kim Beard. I'm Education and Training Coordinator, and I'm joined here today by Debbie Jennings, our Director of Highway Safety and Special Projects. Hi, Debbie. Debbie will be keeping an eye on that Q&A feature and the chat throughout the webinar, and will respond as much as she can at the end with Adele's help. I'd like to introduce Dave Medeiros, our President of Chesapeake Region Safety Council. And then I hope Michael Sakata, President and CEO of MTBMA, can say good morning as well. All right, Dave, I'm going to pass it to you, sir.
All right, thank you very much. Good morning, everybody. It's very exciting to be here, especially with our partners MTBMA participating with us with this webinar. And my name is Dave Medeiros. I'm the Chesapeake Region Safety Council's president. And we are, I don't know where you are, but we're enjoying a wonderful winter wonderland day. And I could not think of a better way to enjoy a webinar to its full extent. And so if you leave early, you're going to miss out on the good stuff. But I want to bring something to your attention real quick, and it's a brief plug, but since you have your phone out, and Kim Beard asked you to bring your phone out, if you look at this slide right here, down in the lower left-hand corner is a QR code. And what I would love to do is ask you all to click on that QR code when you have an opportunity, and it's going to take you to a web page. The web page has our work zone safety pledge. The reason why we're promoting our work zone safety pledge is to get drivers engaged as they drive through work zones. Our state has been plagued with some terrible crashes in the work zones and some heart-wrenching fatalities recently. And we are trying to establish a grassroots effort to get to the individual driver that's going down the road and to get them to take the safety pledge and engage with 3 behaviors when you're driving through the work zone: slow down, move over, and pay attention. If you've ever worked in a work zone, or if you've ever even changed a tire on the side of a high-speed highway, your heart is just pulsing at a very high rate of speed. And what we want to do is we want to be able to give these folks that are working on our highways the best opportunity they could possibly have to go home and spend the evening with their families after they do their jobs each and every day. So I want to welcome you. I want to encourage you strongly to scan that little QR code down on the bottom and take that safety pledge. It'll take you probably about 30 seconds to make it happen. And then just think about it as you're driving through work zones. Slow down, move over, and pay attention to what you're doing. And so without further ado, I'm going to let the others talk a little bit about our speaker today, who is Adele Abrams. And if you've never heard Adele speak before, you're really doing yourself you're just not doing yourself a favor. You need to listen to what Adele has to say. She's got a lot of great information. She's going to talk about cannabis and how it impacts us and some of the legal ramifications and all that great stuff. And without further ado, I'm turning this over to Michael Sakata.
Dave, thank you very much. I appreciate your comments, the pledge, all this stuff. A lot of folks know Dave. I've had the pleasure of knowing him the past few years, and always can count on him, and can't think of a better partner to go down this path than Chesapeake Region Safety Council. I appreciate their pledge. And we all know, if you've heard Dave, when Dave says something, you listen, and I took away obviously a lot of things from that, but definitely pull out your phone, take the pledge, the three things: slow down, move over, pay attention. And so thank you, Dave. Thank you, Chesapeake. And I think want a quick introduction to another person who a Titan over industry, Adele Abrams. Adele, actually, by the way, we had a little history. Her and I worked at my previous stop, American Road Transportation Builders Association, together. Besides that, she's an attorney, obviously smartest person in the room when she's there. Last person to get off the mic. So let's kick this off now. Adele, thank you.
Okay, well, thank you. And let me go ahead and get my slides up here, and we'll do the thing that we do. Everybody see that okay? Give me a heck yeah.
Yeah.
Looks good. Yep. Thank you.
Right. We'll get rolling here then. And I do want to echo what Dave said. Literally, while he was talking, I took my phone, I took a picture of that QR code, and I took the pledge. So we've got 70-something people on here live. Let's be the first 70 to sign up on this and get that campaign rolling. So again, thank you for giving me the opportunity to speak on this with you today. And there is an awful lot new to talk about. I mean, I speak on this topic a lot for Chesapeake Region Safety Council, and every time there is something new to add. But to start off kind of at that 15,000-foot level, as I think is appropriate, the issue of cannabis in the workplace is one of those weird intersections of safety law and HR law. And you have to be careful. This is really the important thing, not to operate in either of those silos in a vacuum. The right hand does have to know what the left hand's doing here for a whole lot of reasons. The safety department, maybe they perceive somebody they think is impaired, and they find out that they have a medical cannabis card, and they decide, okay, they got to go, and they don't consult with the HR director, who may have an entirely different take on this. And so I realize we may have people from both disciplines here on the call, or even worse, that person who has that dreaded task of having to wear both hats. But understand that the right side of your brain and the left side of your brain have to be communicating and understanding the entire spectrum of ramifications, both good and bad and indifferent, that can arise from a worker who is using cannabis medically. And now we have recreational to contend with in the DMV, as I call it, and many of us do, because recreational cannabis is legal in Maryland, in DC, in Virginia, in Delaware. I'm in the snowy, lower, slower Delaware right now coming to you. Pennsylvania is probably going to be adding that pack. Recently, I drove up to see my large adult children in Maine, and I realized that literally every state that I drove through, from Delaware to Maine, is now a legal recreational cannabis state. So we have a poll here for people to jump in on, get an idea of what state you work in. That will give a flavor, I think. I'm going to be touching on most of the states that we have listed here in terms of what their rules are right now in terms of cannabis in the workplace. But then there's another issue, which is you may live in one state and you work in another state, or perhaps your company is headquartered in Pennsylvania, which does not have recreational cannabis, but they have one set of rules, which we're going to go through on medical cannabis use. But then you're at a work site in West Virginia, or in New Jersey. And it's a real crazy quilt right now that is, quite frankly, screaming out, I think, for federal legalization and bringing some harmony to how these laws are going to be applied. But in the meantime, as we'll talk about, at the federal level, you do not technically have ADA protections, Americans with Disabilities Act, if you are a medical cannabis user. If you're a legal prescription opiate user, however, you are covered under the ADA. And, I know Kim likes it when I talk about this perhaps, but it is a fact. If you have zero tolerance for medical cannabis as part of your substance abuse prevention program, and yet you're telling your medical review officers, if somebody tests positive for opiates and they have a prescription for it, don't report that to us as a positive test. What you're doing as a company is really making a policy decision in favor of opiate use. And clearly we have an opiate epidemic here in the US. Yesterday, literally, or 2 days ago, I was at the Mechanical Contractors Association meeting, and I went through an hour-long class on training how to use Narcan. And boy, the construction folks in that room, when we started talking, everybody there had either somebody OD on their job, or it had happened to another trade on their job. I've actually had several clients who've had people fatally overdose on the job. So, if you're tolerating opiates, and you're not tolerating medical cannabis, which is not only used as an alternative for pain management, as well as for an alternative for things like Xanax, which can also be impairing on the job and addictive. You're just sending a message to your employees who are managing chronic pain, PTSD, sleep disorders, and other things for which cannabis is used, that use the things that you can overdose on, use the things that are addictive, and you can keep your job. So that's why I'm saying, I'm going to talk about the federal changes coming in a minute here, but it's put us in a very bad situation where some states are allowing some things and require you to tolerate some things of your workers. Other states say, nope, you got zero protections. You can fire them simply because of that, their election to use medical cannabis in lieu of using, OxyContin or Vicodin or Dilaudid or any of the other things that might be out there. So at the same time, you've got this tension as well with OSHA and MSHA, the Mine Safety and Health Administration. OSHA says you have to maintain a workplace free from recognized hazards that can cause death or serious harm to workers. And somebody who is drunk as a skunk or who is impaired from drugs is clearly going to be a direct threat to safety in the workplace. And if that is known to employers, after the fact typically is when this gets enforced. You say, oh, well, I thought that I smelled something on them, but I didn't want to bust their chops, and then they're involved in a fatal accident in the workplace. OSHA can cite under the General Duty Clause, Section 5A1 of the OSH Act, if it is foreseeable that something could have occurred. And if you haven't heard this before, I'll break another painful piece of news to you, which is OSHA and MSHA penalties just went up again, effective January 16th. So, just 3 days ago. And the new maximum OSHA penalties are a hair over $161,000 per violation. MSHA, Mine Safety and Health Administration, they actually have a codified standard for metal and non-metal mines that prohibits anybody from being under the influence of alcohol or narcotics, and they call it narcotics in the rule, or possessing them. And that applies to contractors as well. The last 2 cases I had on this, both involved contractors, and one was told by MSHA to open their toolbox. They had a bag of weed in there, and they got cited as a company, and their customer, the host employer, they got cited as well. And the latest one I had to do with alcohol. And sure enough, somebody called MSHA to say, we have a contractor here, and I think he's drunk. And when MSHA showed up and asked the guy, have you been drinking? He said, yes. They said, do you have any alcohol here? He said, well, it's in my car. And he opened up his car, and sure enough, he had a bottle of bourbon in his glove box. So, these things are going on. It's not just all about cannabis. There are certainly other things that people are using on the job that are impairing and even, are causing fatal overdoses. But all of those, it's your obligation as an employer to make sure people are fit for duty. And that phrase I'm going to circle back on because, to be blunt, that's kind of the trend is not focusing so much on the substance or the level, but can the person safely perform their job? You know, is there any reason, including stress or fatigue, why the person is not fit for duty that day? But, you know, that requires a more sophisticated level of analysis in some situations rather than just picking an arbitrary number and saying, well, if you exceed this, you can't work here. We know that everybody's having staffing problems, and we know that, you know, finding people who can pass a drug test contributes to those. So this is why I think we're at the cusp of a changing paradigm here in terms of how drug testing is going to be addressed in the workplace. I will add, when it comes to drug testing in workers, you know, OSHA and MSHA also are attuned to the fact that sometimes employers can use drug testing as a bit of a club to either try to find an excuse to fire the worker and not have to pay workers' comp, which, you know, leaves a victim of an accident. Maybe they were injured, not through any fault of their own. And I've had those cases where they are ineligible because of the drug test that was administered when they were brought to the hospital, even though they were not the causal agent in that. So the policy with OSHA has been evolving, and I'm going to address the latest iteration of that. MSHA, they've been kind of silent on it, but on the other hand, they have the same whistleblower protections that OSHA does. And anytime you are retaliated against because of reporting an injury or an illness, that is protected activity. And so that's the linchpin why OSHA and MSHA, even as they're saying you can't have anybody who's high or drunk, they're also saying you can't retaliate against somebody by using drug testing to deter them from reporting an injury. So moving right along here, what's going on the legislative, the legal front? Well, there's a lot of new cannabis laws. You know, I think I did this about this time last year. So these are all things that are different. You know, dozens of new laws, and I haven't captured every single one. But the bottom line is the majority of Americans now live in a jurisdiction where adult recreational use of cannabis is legal. Remember, I used to say most people live where medical cannabis is legal, but that has gone through a quantum shift here. In Maryland, recreational is now legal. It's already being sold in the medical dispensaries. They were right on the dime, man, to get those tax dollars, and so they converted them very quickly. Connecticut, people can now grow it at home. Virginia, they've made some additional changes in their medical cannabis programs, and I am going to go through the Virginia statute in a little bit of detail here for you. Nevada also made some changes. New Hampshire, you can now buy weed there if you are an out-of-state patient. So if you have a Maryland or a Virginia or a Delaware medical cannabis card, and you go to a medical cannabis dispensary in New Hampshire, you can buy it there. Why would you want to do that? You know, in some states even, and more states are having reciprocity among states. Maryland is one of the more favored states now. Delaware is not. I will say Delaware doesn't play well with anybody, and so Delaware's been kind of left out of this. DC, I think, will accept any medical card from any state now in their medical dispensaries. Can't speak firsthand. I've never been in a DC dispensary, but it's important for a couple of reasons. One is medical patients typically pay a lower tax rate, or in some cases, like Maryland, no tax. But also the strength of the products that are sold medically is typically higher in states than it is for recreational. And I know, you know, that's always been something that comes up as well. Okay, I smoked weed back in college, but, you know, you had to smoke 5 joints to feel anything. And now the stuff is, you know, 5 or 10 times stronger than what it was back in those days. It's true. People, especially medical users, though, are not sitting there smoking 5 joints of the finest, you know, 28% THC weed. They're tending to use less of it to manage pain. And it just means if you're smoking it, you're having to inhale less of a product. But also the edible products that are available are stronger for medical patients than they are for recreational. Again, you know, it's a cost thing because, you know, can somebody take a low dosage recreational edible and just eat 5 of them to get up to a medical dose? Certainly they can, but they're paying 5 times as much for it. So I guess that's the deterrent in terms of recreational abuse of those kind of products. California, Louisiana, a bunch of expungement has gone on now through new laws. Maine, they have now limited or eliminated the ability to test people who are on probation for cannabis because it's legal recreationally there. And that's a trend I expect to see in other states. And then Delaware, kind of later in the game, Delaware, Ohio, and Minnesota legalized adult use. And Ohio kind of surprised me. They were on my list last year to go medical, and they just went right to recreational. And Minnesota did a little bit of a quarterback sneak where it wasn't really debated. They just kind of boom announced it toward the end of last year. Kentucky, one of the last southern states to fall, they've legalized medical cannabis now. And for those of you who might be going on a cruise coming up here this winter, the U.S. Virgin Islands, they have now legalized recreational cannabis. Puerto Rico, they have medical. But if you have a medical card from any U.S. state, they will serve you in the Puerto Rican dispensary. So now you have all your winter vacation plans squared away. A few other things, where are we on the scorecard? Well, like I said, the vast majority of the states now and the territories have legalized medical cannabis. We're up to 23 states now with recreational cannabis. 24 states have enacted marijuana expungement laws. And so already there have been 1.7 million criminal records that have been wiped. And that's good news because, you may be working in a field where you do criminal background checks on your workers, and you may have a whole bunch of otherwise eligible applicants that were being kicked to the curb because they had a marijuana possession charge, years ago. So I think these kind of moves are really going to help the employment crisis that we have. There's 10 states now, plus the District of Columbia, where their laws prohibit employers from either firing or refusing to hire somebody because they're using cannabis off the job. And, those laws are continuing to increase, especially as you start having recreational use off the job. Intuitively, you wouldn't be able to hire anybody if you said you can't drink beer on weekends. And when this is starting to be viewed in the same casual context recreationally, hey, I'm sitting around watching the football game and I'm sharing a joint with my buddies. You're saying now, 3 days later, I'm going to test positive, but I'm not impaired. I can't work there. That's the tension that we're coming up with, where you have the majority of Americans living where they can buy it legally, use it legally. And it just comes into tension with their workplace. I'm going to shout out for Normal. Not because, I'm a card carrying member or anything, but because they have the best website, truly, in keeping up to date, not only on the state laws, but also local cannabis laws, and finding where the employment protections are, finding, how much you can grow, how much you can possess, are there driving laws that apply? It's a really good source of information, and they have a good team that just updates it regularly. So I have found that to be really my go-to source. And, one of the things I saw on Normal that really didn't make it into the press, just to give you an example, is in July, the Michigan Civil Service Commission said they're ending pre-employment cannabis screening for virtually all Michigan state workers. Law enforcement is the exclusion there. And anybody who had applied to work in Michigan state government before can now reapply if the reason that they were excluded was because of a failed test. And I was looking at the Normal website again, preparing kind of to update this. And Utah now has a similar thing where if you are a state employee other than law enforcement, you cannot be discriminated against for using cannabis at home. They have medical cannabis there. So, you've got to keep a track of this. I know we're talking to a regional audience here today, obviously, and I'm in that region. But I know a lot of your companies have nationwide operations. You may be a safety person or an HR person who is tasked with managing safety in multiple states that may be outside of our Chesapeake region. So that's why I'm going into a few of these things a little bit. Now, what about at the federal level? Because that's really where the action is, as the saying goes. Federal decriminalization is, I'm going to say, highly likely, and it's more likely now than it was in December. Why is that, you may say? Well, I think it was around January 12th, so, just it was earlier this week, a new report came out by the Food and Drug Administration and NIDA, which is the National Institute on Drug Abuse, 250-page report saying, it needs to be declassified. It needs to be moved from Schedule 1 or 2 to a Schedule 3 drug, which means you can get a prescription for it. Excuse me. I'm getting choked up over this. Ketamine, testosterone supplements, those are Schedule 3 drugs, which means you can't go buy it over the counter, but you can get it by prescription and you can legally use it. The review by the Food and Drug Administration said there is scientific support for therapeutic uses of marijuana, and specifically, they pointed to anorexia for treating chronic pain, nausea and vomiting related to chemotherapy. And of course, there's already been a lot of recognition, including through bipartisan, yes, I did say the B word, bipartisan legislation that was introduced this year. I keep saying this year, 2023. It did not pass. There were the Republicans in the Senate who blocked it, but I think it's going to come back around this year before they adjourn, because the bill can be reconsidered. And this would allow veterans to obtain a medical cannabis recommendation from the VA, which would enable them to legally buy it and legally use it. Right now, veterans are really in a quandary. So many have chronic pain, PTSD, that hypervigilance, sleep disorders. And in fact, and Debbie will probably talk about this at the end, we've been doing, Chesapeake Region Safety Council has been doing green labs, and a lot of the patients are veterans who've been participating in those. They're contributing to our safety research. It's a wonderful thing. And yet, under the wrong set of circumstances, they can be thrown out of the military if they're active military. They can even have benefits cut if they catch a criminal charge related to cannabis. So this is kind of long overdue, and the fact that it is bipartisan, I think, speaks highly for its passage. But the bottom line is, President Biden has already called for declassification. He asked DEA to be looking at it. Now you have FDA and NIDA who have chimed in, and I think that this is going to happen this year. I think he wants to make sure this happens on his watch. He may or may not have a second watch after the elections. But I think there's also, the Republicans want to take this away as maybe a ballot box issue. A lot of young voters are in favor of legalization. And if it hasn't happened through executive action or through congressional action before then, I think that a lot of the Democratic candidates are going to leverage that. So that may be why we're seeing bipartisan agreement. I don't know. But what does the bottom line mean out of all of this? Let's go with the rescheduling first. We're not even talking about wholesale legalization here. If it is moved from Schedule 1 to Schedule 3, all of the federal ADA case law that employers have been relying upon, for almost 20 years now, that goes out the window, because the only reason medical cannabis users are not protected under the federal ADA is because it's an illegal drug. It's Schedule 1, it's classified as akin to heroin and cocaine. And now the researchers have said, that it does not have the risk of significant harm. It has potential medical benefits. It's not as prone to abuse. It's not physically addicting, and all of that. So that's really what we're looking at here, is a quantum change in the legal environment as soon as this happens. And in the meantime, as I'll talk about, there have been some changes where a lot of the states already are either embedding protections right in their cannabis legislation, like Virginia did, or they're cobbling together a safety net by using their state versions of the ADA. And, you know, Maryland is one of the states that has not chimed in on this yet, but Maryland's Human Rights Act, you know, easily could be used to support a finding that a medical cannabis patient is not a user of illegal drugs in Maryland. You know, same thing in Virginia. Delaware already has protections. DC has protections. So we'll continue on here. What about OSHA's perspective on this? We were in a bit of a ping pong game initially because under the Obama administration, which is where this really first came up within the context of the OSHA record keeping rule, where they said if you retaliate against an injured worker by automatically testing them just because they were injured, we're going to view that as a violation of their rights under Section 11C of the OSHA Act and also under the codified protections, which is 29 CFR 1904.36. Then the Trump administration came out and they backed it down some. All of the administrations have agreed from the outset, random drug testing, OSHA doesn't have a dog in that hunt. Really, any drug testing unrelated to an injury or an illness, OSHA wasn't too concerned about. And under all of the administrations, they agreed if you had to test legally for DOT, for example, that was fine. If you had to test due to a contractual obligation, workers' comp coverage, or a complex construction project or a federal contract, you could do that. So really, the only area where they were differing was, what about if none of those exceptions applied? You've got an injured worker, they're lying there on the floor of your warehouse, they've just been hit by a forklift that they didn't see coming. You know, can you test them or not? And under Obama, you could not, unless you had a reason to suspect that that individual was impaired. You bent over them and they smelled like they had had lunch with Jack Daniels. Okay, now you could test them. But under Trump, you could only test them, or excuse me, you could test them without reasonable suspicion, as long as you did it in the context of doing a root cause accident investigation. And you also tested anybody else whose conduct could have contributed to the accident. So the forklift operator in that scenario would get tested, as well as the person that they hit. And if there was a problem with the brakes on the forklift, maybe the mechanic who had just done work on it, maybe they get tested too. Well, then the Biden administration came in and they also had reopened the record keeping rule. And so everybody was holding their breath to say, you know, what are they going to come up with now? Well, surprise, surprise, surprise. They actually endorsed the Trump interpretation. And they not only endorsed it, but they embedded it in the whistleblower manual update that they did at the end of 2022. So that is the official OSHA policy now. You are now back to being able to drug test somebody, even if you don't suspect impairment. And this is from OSHA's perspective, not necessarily every state, but OSHA, as long as you are doing it pursuant to a root cause investigation. If you don't do a root cause investigation report and the employee complains to OSHA because you fired them, you know, you may be back on the hook for being cited by OSHA under 1904.36 for violating that worker's rights. You can be fined up to 161 grand, or they can take the route of complaining to OSHA under 11C, and then you end up in district court looking at punitive and compensatory damages. So, you know, neither one is a place you want to be in. So again, don't just arbitrarily, you know, drug test people hoping that you catch them positive so you can fire them and get out from under those costs. You have to have a reason for doing that drug testing. But that drug testing reason can be part of the root cause investigation. We have another poll question here, getting a sense of how many folks out there are working in a safety sensitive position. So if you could answer that, that would be great. And then we'll get these poll results, I guess, at the end of the presentation here. So moving along here, let's take a look at Maryland and their legal recreational cannabis, because that's the new kid on the block here, right? hasn't been in effect even for a year yet, but sales began almost immediately as of July 1st, 2023. I've got the amounts there that you can possess, and that's considered personal use amount. So, if you happen to see somebody and they had, a fairly hefty looking bag of weed in the workplace, don't assume that they're, a drug dealer. That is consistent with a personal use amount in Maryland. They've also, got some tax bills that came along with this. They did put in a provision for expunging any cases where you were arrested for possession of less than 10 grams of cannabis, and they're going to be looking at additional expungement provisions as well. They're looking, doing some data collection. They've established a Cannabis Public Health Advisory Council, which is going to continue to advise the General Assembly. Right now, there are no employment protections in the Maryland law, but my understanding is the General Assembly, which in fact, I checked it again this morning. They haven't, there are a couple of cannabis related things that have been in the hopper, I guess, but expect to be seeing some employment protections there. Now, a couple of other things about the Maryland law. It is illegal to transport cannabis across state lines. How enforceable that is remains to be seen. If you live in Bethesda and you're going to a party at your friend's house across the line in DC, can you bring your own weed to the party? Technically, no. Can you go across the line and buy more in DC? Technically, yes. But the bottom line is, I'm sure there is a fair bit of transportation going on. I'm over here on the Delmarva Peninsula, and it's legal now recreationally in Delaware, Maryland, and Virginia. But Maryland is, I believe, still the only state that sells it recreationally. So are people from Rehoboth Beach going down to Ocean City to buy it? You bet. I'm seeing a lot of cars with Delaware tags that have the bumper stickers with the Maryland dispensary logo on it. Now, is that a wise thing to do if you're trying to get stopped by the cops? Probably, but you do you, right? But the bottom line is you can't transport it still. You can't bring it onto federal property. If you go over to the Aberdeen, military base, or you go to Fort Meade and you have it on you, you're going to be in trouble because that's still technically illegal federal property there. So, the national parks, you go to Wolf Trap, that's run by the National Park Service in Virginia. That is not a safe zone, even though Virginia has recreational cannabis. So bear that in mind. You can still get jammed up with the feds, even if you're within a legal state. Now, what about employment? The Cannabis Reform Act that Maryland passed does not address impairment in the workplace or use in the workplace. So right now, you're still subject to existing laws. They also don't address drug testing in this new legislation, but there are older laws in Maryland. It is one of the split sample jurisdictions, and that became a problem initially with those oral mouth swabs where you couldn't do the split sample and get it reanalyzed. And really, those aren't a drug test. Those are being used more as a threshold screen, I think, by companies. And as long as you're not taking adverse action based upon that, you're simply using that as a threshold referral for a more in-depth drug test, you may be okay. But the manufacturers have come up with the split samples on those now anyway, so they got around that. Now, beyond that, the recreational cannabis law does have a couple of provisions that employers should be aware of. One is that it's been added to the indoor smoking ban. Not that I expect that most of you, would be letting people light one up at work, but you can't. You can't smoke cigarettes there. You can't smoke cannabis there. That's a good way to remember it. And employees who maybe drop a dime on you to the Maryland Department of Environment or to MOSH because somebody is smoking in the workplace, whether it's cannabis or tobacco, they are protected from any kind of retaliation specifically. Also, when it comes to driving, you can't smoke cannabis in a car in Maryland if you're a passenger. You can eat it, but you can't smoke it. You can have a patch on, you can use tinctures, but you can't smoke it. If you're driving in Maryland, you can't consume cannabis in any form. So that's the nuance there. And that is in a vehicle, on a public road. What about if you're sitting in your driveway? Well, that's a private road, at least in most circumstances. If you're in an apartment complex, the parking lot there might or might not be considered private. What about your work site? You know, that might be considered private property. I guess then it's up to you whether to let them sit in a work truck and smoke it. But that is something that, you know, you do have a hill to die on. You can ban use of cannabis products by anybody who is operating a company vehicle. That is certainly okay. And then, as I said, the Maryland General Assembly, we're just in January. They're just coming back into service, but I expect there will be additional workplace protections added there. They're not going to leave Maryland as kind of an island with no protections amid all of the other states around them that do. It would be an employment disadvantage for them to have, you know, a draconian rule when the other states don't. Pennsylvania, I want to mention them because I do think recreational cannabis is probably going to happen there this year. The bill numbers that I mentioned there were from the last session. And, you know, they're looking at legalizing recreational, allowing medical patients to grow it at home, setting up an advisory board, and also expungement and ensuring some social equity for their cannabis businesses. And Maryland ran into some trouble with that, where when they first opened their dispensaries, almost all of the licenses were given to Caucasian applicants. And I think either none or virtually none of the people of color who had applied for licenses were granted them. So they ended up reopening that process in Maryland. And now that's something the other states around here are taking notice of as well. But here's what I wanted to point out really with Pennsylvania is that they went the extra yard, trying to figure out safety and medical cannabis. They have protections in their law. If you are a registered medical cannabis patient in Pennsylvania, you are protected from unfair discrimination in the workplace, but they do not require employers to violate federal law. So that would be DOT or federal contracts. And they also identified what they call high-risk activities where a patient cannot use medical cannabis in order to ensure a safe workplace. You cannot discriminate against someone for their status as a patient. And that has come up in a number of these cases. I'm going to, at the end, very quickly hit a few to give you examples. But the fact that somebody has a medical cannabis card doesn't mean that they're using it during work or they're going to be impaired. And some people who have medical cannabis cards are the caregivers for someone at home who may be a cancer patient who can no longer drive, or somebody who is blind, you know. And so the fact that they have a medical cannabis card doesn't mean that they ever use it themselves at all. It sounds kind of silly, but honest to Godfrey, this week I had a client call me and they said, we have an employee, and, you know, they're a good employee, and they told us that they don't use cannabis, but they told us that they live with somebody who does, and we want to know if we can fire them. And I'm like, why are you looking to fire this person? Have they flunked a drug test? Well, no, but if they're around it, they're probably sharing it. You know, that is such a misunderstanding about medical cannabis. The same thing, I guess, by extension, you could say if you have a household member who uses opiates, you know, because they have cancer, then you can't work here either because you're probably stealing their drugs. So, you know, let's be rational, folks. You know, let's not, you know, engage in reefer madness here, please. But in Pennsylvania, going back to them, they, first of all, picked a 10 nanogram blood THC level as being a level at which you cannot, be in control of chemicals that require permits or work with high voltage electricity or other public utilities. Now, the problem with that is several years ago, there was a consortium of sheriffs that met and they issued a report where they came out solidly advocating against using blood THC levels for any purpose because it is not consistent with identifying impairment. It's a lagging indicator, kind of like the hair tests are. And so this is a bit outdated. I would expect at some point Pennsylvania will probably correct that because all that shows is somebody used it in the past, but not that they're actively impaired. You don't have to accommodate medical marijuana. They did put that in there, so that kind of negates the use of the Pennsylvania version of the ADA for that purpose. You can discipline people for being under the influence of medical cannabis in the workplace or working under the influence of it, but only if the conduct falls below the standard of care normally accepted for that position. And I want to tell you, there's the same test in West Virginia as well. And I think Kentucky may use that same test as also. In addition, you can specifically prohibit patients from performing mining activities. That's a huge one in Pennsylvania, not only because of all the coal mines, but there are a lot of stone, sand, and gravel operations, quarries up there, cement plants. Pennsylvania loves its road projects. And so that has had an impact on those industries' ability to hire people. Also, any employment duties at heights or confined spaces. And, certainly those are definitely among the most obvious causes of fatal accidents is falls and confined space entry. But again, they say, well, under the influence of marijuana. The problem is, their influence, if they're using the 10 nanograms blood for that, rather than, a better cutoff value using a urinalysis test, that's going to eventually jam them up. And I'm waiting for some bills to come out here. Another thing, though, that they did just pass in Pennsylvania was removing the list of qualifying conditions. So a physician now, at their discretion, can recommend medical cannabis for any condition, not specifically enumerated ones. Medical cannabis in Virginia and employment, they went, the full Monty here. You are protected as a medical cannabis patient from being discharged, disciplined, or discriminated against. And that took effect back in July of 2021. So if you have a positive test and you're a medical cannabis card holder in Virginia, you cannot be terminated solely on the basis of that positive test. If there's a code of conduct violation, or something else, you weren't wearing your fall protection when you should have been, sure, you can discipline them for that infraction, but not for the drug test. There are some safe harbors in a couple of regulated jobs, mostly in the medical field and law enforcement. And then, interestingly, the carve out that they did for the defense industry, I think, is very illustrative of maybe the direction people should be going, because they say you can't refuse to hire someone unless their nanogram test is above 50 nanograms, 50. Many companies are using 50. The federal agencies recommend 50 as the cutoff value. But the problem is, a lot of times the companies use a lower confirmatory cutoff. 25 nanograms is pretty common. And I've had cases where the worker who was injured passed at 50, but then they came in at like 30 or something. Yes, does that indicate use? It does. Does that indicate impairment? No. So look at what you're using for your cutoffs. Don't do the limbo rock. How low can you go? And expect that, you're going to have people passing it when we now have recreational use pretty ubiquitous, at least in certain populations, the younger folks and probably the baby boomers too. Now in Virginia, they did throw a bone to the employers and said it's a complete bar to recovery from workers' comp if the injury results from intoxication, and that's drugs or alcohol, but the intoxication has to cause or contribute to the injury. So in my scenario, if I'm walking, minding my own business in a warehouse in a pedestrian delineated lane, and suddenly, Dave Medeiros roars up silently, of course, on an electric forklift and nails me from behind, I don't care if I smoked a joint that morning. My impairment was not a causal factor in that accident. Now, if Dave had been yelling, Adele, get out of the way, my brakes don't work, and I'm bopping along listening to the music in my head and not paying attention, then you could say that the impairment contributed to the accident. So these are going to be very much fact-specific, case-by-case analyses. And, in some cases, they may be made by a jury of your peers. California, I just wanted to note, because this is kind of a harbinger of things to come. California is always a trendsetter. They were the first medical cannabis state in the country. And now this new law that just took effect this month bans discriminating against workers based on urine drug test, any drug tests that rely on the inactive cannabis metabolites. Now, this is on hold right now because the California Chamber of Commerce wants to evaluate this for a year. But what does that mean? If they strike down the use of urinalysis tests because really they're not consistent with impairment, and hint, that's kind of true, unless they're off the Richter scale. What does that mean? I think that means we're going to be shifting again more to a fitness for duty analysis, or the tests that are coming out, the Hound breathalyzer, which purportedly can capture cannabis that's smoked, vaped, or eaten within 3 to 5 hours of use. And that's really the sweet spot. That's when people are feeling the effects of it. People who are microdosing for medical purposes, that's going to be a little dicier because you're using it maybe multiple times during the day, just like you take Tylenol more than once during a day for pain management, but they're not using it at a level where they're getting impaired. And more about that here in a moment or two. Drunk driving laws, more and more states now are amending their DUI laws to consider that cannabis is there. This is, again, part of the green labs that the Safety Council here has been working on, is to assist Maryland law enforcement. And now it's going to be branching out to Virginia, as I understand, in training their officers to better recognize impairment from cannabis, because most people who are using weed can pass a drunk driving field sobriety test with flying colors, and they're going to pass a breathalyzer unless they've also been drinking, on top of using cannabis. If they're, vaping, if they're using edibles, you're not going to have that telltale Cheech and Chong smell. So it is difficult for law enforcement to definitively, document to a legal certainty beyond a reasonable doubt that somebody is impaired by cannabis currently. So that, more to come there. Just a few things on these cases. The Knopfsinger case was significant because the employer brought this in federal court based on a preemption claim. They said, well, we can't hire a medical cannabis user because they're an illegal drug user. And the court rejected that. They said the Federal Controlled Substances Act does not regulate employment. It is not illegal to hire somebody who is a cannabis user. But also, this was brought in federal court, but they considered it under the Connecticut medical cannabis law, which does have protections for workers. And so we're seeing some of that crossover there. At the federal level, though, it's still been reaffirmed, because it is illegal currently federally, you have no protections under the federal ADA. Walmart won one of the first cases on that, Cassius case, and yet they just lost a major case in Arizona because Arizona has built-in protections for their medical cannabis users. And somehow Walmart missed the message. They ran the same playbook that they won on in federal court, back in 2012, and then they lost big time, over a decade later. Darlington, this was another one where they fired somebody just because she said she used medical cannabis, even though she said, I won't use it and come to work. She was using it to control migraines, a fairly common use for it. And because the Rhode Island medical cannabis laws had protections, the employer lost in that. So at this point, we have a ton of states, as I mentioned, that have employment protections. There are more coming. Arizona, Connecticut, Delaware, Illinois, Virginia, Maine, Minnesota, Nevada, New York, New Jersey has built a safety net, and more of these laws are being reopened to embed employment protections. So if you haven't looked at the states that you do business in recently, you probably need to go back and revisit those and make sure that whatever your drug testing regimen is still valid in all of those states. Another area where things keep changing is workers' comp. And I'm not talking about denying people workers' comp because of using cannabis. I'm talking about treating workers' comp injuries with medical cannabis. It's no secret that a lot of people who are addicted to opiates got that way because they started off taking them for workers' comp injuries. There are other complications, including things like constipation resulting in bowel impaction, and sepsis and death. So, more and more states now are recognizing that medical cannabis is a valid alternative to opiates for treatment of workers' comp injuries. Pennsylvania is the latest case that I read in detail, in part because I practice up there. And just last year, they held that the employer violated the Pennsylvania Workers' Comp Act by refusing to reimburse them for medical cannabis. Yep, that's right. So you're buying it for them, just like you're reimbursing them for the opiates or other medications that they would buy for treatment of workers' comp. This is a very typical case. The person had medical treatment and, for pain relief from a workers' comp injury for 30 years. They were taking narcotics. Of course, they were addicted. And the bottom line is that, this is how it goes in Pennsylvania now. But they drew a distinction between reimbursement and coverage. So for workers' comp, if a worker's doctor recommends that they use medical cannabis, you do have to pay it back through your insurance, or if you're self-insured, you're doing that directly. But you do not have to include medical cannabis in your prescription coverage plans for non-work related medical care. So it's a nuance, but it's an important one there. So here's the spreadsheet on this now. There's 30 states, though, that have not even considered the issue and could go either way. The majority of those that have considered them have held that you do have to do the reimbursement, and Pennsylvania now is on that list. Maryland and Delaware have cases that go both ways, so they're kind of in flux. California, Oregon, and Nevada have said you neither have to pay it, nor do we bar you from doing it. That's kind of case by case. And then Florida, Maine, Massachusetts, North Dakota, Ohio, and Washington State specifically prohibit employers from paying for medical cannabis. So again, it's all over the place. Real quick, because I do want to get to the conclusion here, and then I know we have a few announcements and questions at the end. The bottom line is, if you haven't looked at your legacy substance abuse programs in a while, you need to do that. If you're going to test, you need to have a written program. Some of the states like West Virginia require that before you can do testing. You have to have supervisor training, because they're going to be your first line of defense, or they're going to be the weakest link in your chain if they don't know what they're looking at in terms of reasonable suspicion. If they don't know how to document it properly, if they, leapfrog over steps in the process, they're going to land you in court. Employee education on the dangers of working while impaired, and if you're now new to recreational cannabis, spend some time, cover that in your training. You don't have to come off as a prude or a Puritan about it, but just, there's a time and a place for it, and you can't pop a beer here, and you can't go smoke a joint on your lunch hour either. Make it clear what the consequences are. Make it clear that you have an employee assistance program if you do. And if you don't, you shouldn't be drug testing, because you need to have some way for somebody to come up voluntarily and say they need to get help before waiting to get busted on a test. And only when you have those four walls in place can you put the roof on, which is your actual drug and alcohol testing. And specifically in your program, focus on why you're doing it. What is prohibited? Is it impairment, or is it a positive test? What are you testing for? What limits are you using? Who's getting tested? Is it company-wide, or are you only testing certain bargaining units? What availability of assistance do you have? How are you testing? What type of tests are you doing? And if you are union, remember, this is a term and condition of employment. You do have to negotiate this with your union as part of a collective bargaining agreement. If you just change the program unilaterally, you're going to be brought up before the National Labor Relations Board. Reasonable suspicion testing is allowed in all states, but again, it may be subject to some of the limitations that we've been talking about here. DOT is DOT, follow DOT. It's zero tolerance, and they do distinguish between reasonable suspicion for DOT purposes for alcohol, which has to be observed, just pertinent to or during performing their safety sensitive duties, whereas reasonable suspicion for drugs can be really any time. It doesn't have to be right before they climb behind the wheel of a truck as a commercial driver. So, you know, the age-old question here is, what is impairment? And that is really still a quandary. We know that the drug tests and the hair tests really are capturing lagging indicator historical use, but they can't reveal whether somebody smoked a joint this morning, typically. CDL, you know, that's all still zero tolerance. It's becoming a forensics issue in a lot of accident cases, both on the job and off the job in terms of insurance coverage for sure. And I've already talked about the cutoff thresholds. 50 is really what the Substance Abuse and Mental Health Agency and the federal government recommends. And that's kind of where I would stick as well, because you're capturing CBD only products if you're going much lower than that. And Illinois, they've defined impairment. I'll leave this for you to look at on your own, but I do want to mention CBD because it's being used so frequently. It's in seltzer waters now, it's in skin creams, it's in everything, you know, and it's not tested. It's not regulated by the FDA. If you buy a CBD product from a dispensary, it will be tested. It will be a clean product. But the latest study out of the University of Miami, where they screened over 500 CBD products, including over 100 that you were consuming orally, they found 42% of them had lead in it, 37% mercury. You had arsenic, cadmium, other heavy metals, Delta 8. You know, Maryland has a law now. You can't sell this stuff in gas stations. It's only supposed to be sold through dispensaries. You know, we'll see how that goes. But can you get high off of Delta 8? Yes, and it evades drug tests. So that's why that's been so popular. But, you know, those are not safe products. CBD does not cause impairment, but it is allowed legally to have 0.3% THC in it. That's under the hemp laws. And that's why it can tripwire positive tests. There's been a few cases on this recently. Operating engineers had a case, the worker lost, even though they said, I have not used any marijuana, I've only used CBD. DOT put out warnings on this. So did Department of Defense. You know, they banned CBD products because it can complicate DOD drug testing. And a miner recently lost his working papers in West Virginia because of the laws that MSHA has there. So again, a lot going on that slide. But I just want to note that while there are no federal protections under ADA, that will be changing if and when it becomes scheduled differently at the federal level. But also, and this is kind of a new thing, employers increasingly who are disciplining without evidence of impairment are being sued. And one of the defenses is in using products that are very high terpenes that do not cause impairment and low THC. You know, they are customizing these products at the dispensaries, especially to give medical patients relief without causing impairment. And I've given you a little chart here of some of the most popular terps. And as you can see, some of them, you know, myrcene, that is a sedative. Okay, so a high myrcene product might be dangerous in a safety sensitive position. You know, then you get into some of the other ones, you know, that are providing you relief from pain, you know, and they may be energizing. So there are a lot of other terps beyond this, but the key is knowing what the patient is using for the patient, for them to know what effect is it having on them, and having some interface with the employer so that you're not stepping into a disability discrimination case at the state level. Under the federal ADA, you can refuse to hire somebody or continue employing them if they pose a direct threat to safety. But the case law is very clear that simply, you know, having a reefer madness mentality that, oh, cannabis is dangerous is not enough. You know, you having a good faith belief is not enough. You have to determine significant risk, interfacing with their physicians based on scientific or medical objective information, and considering the duration of the risk, the nature and the severity of the harm, the likelihood of the harm, and the imminence of any potential harm. And people who are using it off the job, maybe for sleep disorders at 10 o'clock at night, 10 o'clock the next morning, they are not, you know, or 6 o'clock the next morning, they're not likely going to be feeling any impact from that. So to wrap up here, as ADA increasingly is implicated at the state level, and maybe that's going to be coming soon this year at the federal level, make sure to engage in that interactive process and document what you've considered as an accommodation, what you've rejected and why. Have written job descriptions and accurately label positions as safety sensitive. If you call every job in your organization safety sensitive, from the receptionist on to the janitor, you know, you're going to be laughed out of court. And if they cannot mitigate what you believe to be, you know, a safety risk, you know, again, document what you've considered and why it did not sufficiently mitigate the direct threat to safety, but base it on objective, unbiased, sound medical and scientific criteria, you know, and not just a rush to judgment. Train your supervisors. We talked about that. So check your drug testing programs now against the OSHA record keeping rule that we talked about, against your state laws. Consider going to, you know, a Druid type system, which can capture fitness for duty as an assessment, but it's not considered a drug test under the law. SoberEye is another technology like that. There, you know, more and more of these are coming to market. Flag your job descriptions if they are safety sensitive, so you know who maybe you should be capturing in your testing programs. Negotiate with your union, you know, or put it on your dance card if you're going to have to change up your program based on all of these state law changes we've talked about. You know, if you're negotiating later this year, it should be on the table. Train those supervisors on recognizing impairment and handling it appropriately. I had one horror story where a guy was confronted in the workplace and said, "I think you're under the influence and I'm going to take you to get drug tested." And the guy picked up a nail gun and he shot himself in the head and killed himself. You know, you don't know how people are going to react, so do it safely and treat all employees fairly. Don't discriminate against injured workers or disabled workers and treat them in a disparate manner simply because they opt to use medical cannabis in lieu of opiates to treat their condition. So I'm going to turn this back, or I should say over to Debbie now, who I think had some things to add. Kim, I see you popping up there as well. We have our poll results, and I'm going to be quiet, let you do your thing, and then I'll answer any questions we have. But thank you all so much.
Thanks, Adele. Yep, I shared the poll results for a safety sensitive position, and we may also want to consider federally funded positions that Debbie may speak to as well. Thanks, Adele. A lot of great new information you've shared this morning. So again, thanks for coming. Please stick around. I know if you're in the Mid-Atlantic region, you're probably kind of snowed in anyway. So while Debbie reviews the Q&A, I just wanted to remind you of a few things. Also going to pop some stuff into the chat as I go along here.
And I can vouch that it has switched over to snow on Delmarva here.
Oh, yes. We've got quite a bit here in Baltimore County, Maryland. So we have another, Adele's going to be joining us again, partnering again with MTBMA on March 15th. This next webinar will be covering crystalline silica, new rules and enforcement initiatives from OSHA and MSHA, new things coming down the pike there. And you can click that QR code. And I'll also put this in the chat here in a moment so that you can register for that. Same website that you registered for this webinar as well. And we have some new certificate programs that we're launching here at the Safety Council. We want to bring your attention to. We've got the National Safety Council's Leadership Certificate Program that's getting launched literally in the next couple of weeks on our website. So I need you to check back onto our website and call the office and email with any questions about that, because that's coming up here soon. And the screen shows you a brand new certificate program we're working on and is now launched for the whole worker. We talked about that a lot today with Adele. The whole worker health certificate program. I want you to just take a moment and review the required courses for this. Some of you out there I know have taken one or two of these classes already. So again, I'll put the link in the chat for more information there. And Debbie, I'll get your video here working in a moment. Debbie's going to focus a little bit on 2 of these required courses that play along with this certificate program for whole worker health. And I'll pull up her slide while I give her some rights here to be able, so we can see Debbie while she does your Q&A. There you go, Debbie. You should be able to see your video now.
Hi, everybody. Thank you. Great job, Adele. Amazing as always. Kim has pulled up a slide from one of our much earlier impairment education and cannabis use workshop programs. You have the ability to take a 4-hour class that consists of education conducted by a law enforcement officer focusing on impairment in general. It includes drug and alcohol testing, or drug and alcohol impairment, as well as touches on fatigue and other types of impairment in the workplace and on the roadway. And that's followed by a workshop that is hands-on. We bring in cannabis users, primarily medical cannabis patients, and they have discussions with attendees on why they use, how they use, the length of impairment, if it occurs, and their abilities perceived as to whether or not they can work or drive on the roadways. And then law enforcement officers do a quick assessment of them and share that process with the attendees, not only with the law enforcement students, but attendees in the from the workplace and supervisor training class that just ended. Our next class is March 4th, and we do have some spots available. And if you can't make that one, we do them 6-7 times a year, and we are expanding that program to some of our nearby states. Virginia is interested, and we have funding for it. And we've been in conversations with DC and Delaware. The reasonable suspicion class typically happens immediately before the supervisor's impairment education and cannabis use workshops. That's taught by Dave Medeiros or another staff member. And that meets the federal requirements for 1 hour alcohol, 1 hour drug, and the process used by supervisors to document a reasonable suspicion case. And with that, I'm going to move on to some of the questions. And Kim, I can't see the chat right now, but I believe you're posting links in the chat as well. So the first question, Adele, that I have is, my company has a flat out policy that every injury that requires going for medical treatment must have a drug and alcohol test done. Does this violate OSHA 29 CFR 1904.36?
Well, I'll give the usual lawyer answer, which is it depends. On its face, I would say yes, because you're not distinguishing between injuries where either you suspect impairment or where you're at least doing a root cause investigation. And that's where the depends comes in. I work with some companies that do detailed reports on, every, first aid boo-boo that they get where you put a Band-Aid on somebody's finger. I have other clients that I work with where unless they are actually, getting kind of treatment at an emergency room or in a hospital, they don't consider it. I mean, it's recordable from an OSHA perspective as medical treatment, maybe because they get a prescription medication, for an ankle strain or something, but they don't do a root cause investigation of it because the guy says, I tripped over the threshold when I was, coming in the door and I strained my ankle. If you're not doing a root cause investigation, but you're just, knee-jerk drug testing everybody, and the person gets fired because they, test positive, if they go to OSHA and they file a complaint, OSHA will investigate. They have 180 days to investigate a retaliation complaint under 1904 versus the 30 days under the statutory provision. And if they find that you didn't do a root cause investigation, you just tested the guy and fired him, they can cite you and fine you for up to $161,000. And then what about the person? Well, the abatement of that citation would be reinstating them to that position. So, for the most part, the injuries that would trigger drug testing and medical treatment are likely going to be the kind of things that you would do a report on, and you're fine on those. But let's say somebody has a chronic strain, an ergonomic injury. That would be a good example. And they say to you, I finally have to go in and have that shoulder surgery done, or, the carpal tunnel surgery, and then you send them for drug testing. Well, there was no incident that you're investigating. And so sending them to get a drug test simply because they told you I'm going to have to be out hospitalized to have a hernia taken care of, that would be seen as retaliatory, I think. That was a long answer to a short question, but that's why I say, it's hard. You can't just say yes or no. You have to look at it within the context of, why are you drug testing? What's the nature of the injury? And are you documenting a root cause investigation?
Understood. Thank you. So that we have just one other question, and it's related to resources for determining impairment. I'm going to chat about that for just a second before I turn that back over to you, Adele. And
Okay.
that is during the Green Labs slash what we call our cannabis use workshops. We frequently bring in technology partners. We've brought in the Druid that Adele had just mentioned many times, and we agree that that is a stellar resource for determining fitness for duty. We've also brought in SoberEye, CannaView. We're going to bring in a new one this next lab. It's by a company, and the product is called IMAD, IMMAD, and that is presently being used to determine impairment through some medical causes. And the developer believes that it's got some crossover benefits for determining impairment from cannabis or other drug uses. So if you attend one of those classes, you have the ability to have conversations with those product developers. And we continue to offer all of that experience that entire day for free. So we hope that we get to see you. And Adele, can you follow up on any of the other resources that you think might need an explanation?
Well, as you were saying, I'm most familiar with Druid, and I think that has a lot of promise because you're benchmarking against yourself. When you're hired, they run a series of both cognitive and functionality tests, and you repeat it to get your own baseline when presumably you're clean and sober, and then if either doing it on a regular basis, you're just measured routinely as you come in, and as long as it's within your own parameters, you move on. Now, if a supervisor sees that you're outside of your normal range of scores, then you're doing a secondary interface. The supervisor's talking to you. Hey, you feeling okay today, Debbie? Well, the twins were up crying all night. I didn't get a lick of sleep. Okay. You have no reason to suspect impairment from drugs or alcohol, but maybe she shouldn't be operating heavy equipment that day on, 2 hours of sleep. It captures, again, the things that can put you off your step, regardless of whether it is drug or alcohol based. So it's kind of a no fault system in that regard. And that's why, because it's not substance specific, it isn't subject to the drug testing requirements that are embedded in the Maryland and the other state laws. The actual referral then, like if your score is wacko and the person's like, no, I'm fine, at that point, they're referred for an actual test, and then you're taking action based on that. But I always say on those tests, whether it's SoberEye or Druid or some of these other ones, and there's another one that you didn't mention that I'm blanking on the name of that I've looked into, don't base employment action on those tests. Rely on an actual drug test if you're going to do it, but do use those tests to determine if maybe somebody is off their game that day. We have a lot of people with long COVID and brain fog. Their Druid scores today may be different than what they were a year ago before they had COVID. And those are things that you can capture in these kind of functionality tests too. How would things change? The caveat, I will wrap up with this. The Druid developers did tell me that they had come up with a score number that they believed in most circumstances correlates to a 0.08 blood alcohol content, which is your driving drunk level. But the caveat on that is older workers have higher normal base scores, but they're not impaired. And so, for younger workers, that magic number might be a good indicator, but say for law enforcement purposes, it could have a disparate impact on people who are older, who have slower reflexes, who maybe have balance issues or other response issues because of an underlying health condition. So that's why you really just want to benchmark yourself against yourself in any of these tests. So that's it for that. But these are all the great wave of the future. I mean, we have to get away from some magic P number being dispositive of whether you can work in the United States or not, because it is not a one-size-fits-all approach that's called for here. But again, thank you for all you do as part of Chesapeake Region Safety Council and for putting on these labs, because they're helping with law enforcement and they're also advancing the state of knowledge for employers and employees alike. So thank you.
Adele,
Thank you. And I will add, whoops, go ahead.
Excuse me. Because I was listening to your answer and I have been participating or attending these green labs for ever since we've been doing them. A question I've got for you, okay? And because you brought up about like the Druid and the sober eye, regardless of what the impairment, what is causing the impairment, and I was an employer, I'm trying to address, I want people to be able to function in their workplace. And a lot of times work job descriptions have defined that a person needs to be able to pick up this much weight. They need to be able to stand for so many hours. Would it be in lieu of drug testing to just say, you know what, because of the nature of this job, let's just say, and I'm using it as an example, let's say the company had adopted the use of a Druid piece of their technology. Would I put it in my policy and say, hey, in order for you to work today, you've got to be able to pass, you've got to be within your baseline on your Druid test. Is that an acceptable way to handle it?
I'm going to say yes, but again, because maybe the person isn't performing that well that day, but it's not due to impairment, it's due to illness. You're not going to discipline them for being
No.
ill.
I would say this. I would say this, and I'm not trying to disrupt you, but okay. But whether you're ill or whether you're impaired by a substance is not what I'm looking for. I want
you're
you
still
to be,
not working that day. I'm agreeing with you on that.
You
but
need to be able to function. It's not that I'm going to take action. I just don't want to put you in the line of fire is what I'm getting at.
I agree. If somebody has a pounding migraine and they're seeing colors and feeling like they're going to puke, they probably shouldn't be operating a crane. Whether they're using medical cannabis for it or they're just toughing it out with no medication, they're probably not going to be safe for work that day. And so I agree with you. Where I'm saying it depends is just what is the next step. If you remove the person and it turns out, they explain to you that, they've got a migraine, they were up throwing up all night or whatever, you're going to send them home probably with pay on sick leave. If somebody doesn't have a valid excuse, then they may be sent home without pay. So again, you're going to have to be guided by your employment practices for that. And that was why I said it depends. But I agree, if somebody doesn't pass the safe for duty functionality test, then they're not safe for duty. You can assign them that day maybe to a non-safety sensitive job. If you determine they're not impaired, more likely though, you're going to be sending them home because you don't want them on the work site if they're not with it, from sleep deprivation. They're not going to have situational awareness. They may not be operating something unsafe, but they could expose themselves to an unsafe condition.
Okay. Thank you, Adele.
Yeah.
Sorry, Debbie.
So,
That's okay. I just wanted to clarify one more thing is that for those of you on the call today that want to come to what has been called a couple of times a green lab, please don't search for that on our website. We call that an impairment education course with a cannabis use workshop because of the need to clarify the difference between what the law enforcement training is, as well as some other energy related trainings that use the term green lab. We hope to see you soon on the call that we are having later in March. And Adele, again, thank you.
Thank
Yes.
you.
Thank you very much, Adele. It was extremely informative. Thank you.
Be safe.
You'll